All right, you may have a seat. And we are here for a final pretrial. Is there any resolution in this matter?
There is, Your Honor. The people have offered that if she were to plead to operating while intoxicated, we would not charge the high BAC and there's also jail. The defense does submit for sentencing memorandum and substance use assessment that would help clarify the Killebrew agreement.
Mr. Hartel?
That is accurate on all parts, Your Honor.
Mrs. Hughes, have you heard what the attorneys have said the resolution of this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You may put your hand down. It's my understanding that you'll be pleading what is essentially guilty as charged to operating while intoxicated. That is a misdemeanor punishable by a fine of not more than $500 and or 93 days in jail. And that comes with a suspension of driver's license and also reimbursement for prosecution expenses and the cost of governmental expenses. In exchange for that, the people are agreeing that they are not going to seek to amend the complaint to a high BAC or high bodily alcohol content. There's also a Killebrew agreement for no further jail. Now, a Killebrew agreement just references a appellate case, but what's important to that is that's an agreement that you have with the prosecutor that you wouldn't be sentenced to any additional jail already more than what you've already sat. Now, that's an agreement you have with the prosecutor, not an agreement you have with me. So if I decide that I'm not going to go along with that agreement, you would be able to withdraw your plea. Does that make sense?
Yes.
All right. Back on December 14th of last year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Do you remember reading and signing an advice of rights form in this case, talking about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea, you'll be giving up that right and you won't have a trial of any kind?
Yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Right, then Ms. Hughes, to the allegation that on or about December 14th, 2025 in the city of Cadillac of Wexford County, how do you plead to operating while intoxicated?
Guilty.
It's true. In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on the 14th of December, were you operating a motor vehicle in the city of Cadillac? And prior to operating that vehicle, had you consumed alcohol?
I did.
Do you remember how much you had to drink?
About a half a pint.
All right. Liquor then, I take it? Ms. Dull, are there chemical tests to support the plea?
Yes, Your Honor, there is a lab report that has the BAC at 0.215.
You would stipulate that.
All right. Do counsel believe the defendants provided a factual basis in which to accept the plea with the stipulated blood draw and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court. I found the plea is knowing, voluntary, and accurate. Ms. Hughes, I find you guilty of operating while intoxicated. I have received the documents referenced by Ms. Dull. In particular, it's a Catholic Human Services assessment, a letter from Liz Eastway, a letter from Amanda Boss, Rose Whaley, Sarah R., correspondence from Garrett Banks, Teresa Carey, along with AA attendance sheets. And I believe there was a mitigation report. Either party have any corrections or additions to be made to the substance use assessment?
No, Your Honor.
No, Your Honor.
An allocution, Mr. Hartel?
Yes, Your Honor. As the court did note, my client does have quite a bit of more support in the greater community. Not only those people who wrote the letters, but others as well. I know here today she has her husband and her son with her. They've been supportive of her throughout these proceedings. She's realistic that having a conviction on her record, some of the things that we notice she enjoys doing, such as volunteering, is going to be a little more difficult. I'm hoping she still can. She's not sure. Obviously, this isn't a felony, but it's going to impact her ability to transport people at absolute minimum. We went into that eyes wide open. So just so the court is aware, even if the court does go along with the Killebrew, it's not as if somebody's getting off scot-free, oh, no additional jail. I'm not saying the court would view it that way, but she would have the weight of not being able to provide that service to others. And it's kind of counterintuitive. Some people might view it, or sometimes volunteering can almost be kind of selfish because it makes us feel good when we do it. And unfortunately, she won't be able to get those good feelings of helping other people, what I'm trying to say. It's something she's taken pride in a lot over the years, and she's going to do the best she can to still volunteer, albeit perhaps in a lesser capacity. And she is going to do everything she can to get her license back when the time comes. She just knows that unlike visibly impaired, which subtracts a little bit kinder to Secretary of State, this is going to hit her pretty hard. It's not going to hit her as hard as a high BAC would have, but it's still going to hit her pretty hard. She's realistic that the blood results that we did stipulate to are significantly above the minimum standard for a BAC, a high BAC. She's very lucky things weren't worse. She's very grateful things weren't worse. She obviously isn't like one of our other people that we see sometimes before us, where they're perhaps half her age with a rap sheet that you could scroll out across half this courtroom. And the only reason I mention that is to say that even though this is obviously very serious, I'm thankful knowing that she hasn't made a lifetime career of negative things. She's been trying to focus on positive things. And I do believe this hitting rock bottom has been an awakening for her. And thankfully, she has a very good support structure, the people she associates with, not only those in the courtroom, not only those who wrote the letters, but beyond just that. I don't think we need to worry about her reoffending. I completely understand if the court has concerns and wants to supervise her. But personally, I believe that this hitting rock bottom towards the end of her career, towards, I don't want to say the end of her life, because I think she has a few decades still to go. But honestly, Your Honor, I believe the process alone has scared her straight. I don't even think we need to supervise her, but at a minimum, I'd ask the court to obey the Killebrew. Thank you.
Thank you. Ms. Dole?
Your Honor, I am pleased to find that Ms. Hughes has taken this seriously. It seems based on her AA sheets that she went on the day of the incident and then almost every other day since then, and not since December. And that's a really positive thing to see as a prosecutor, that somebody takes what happened seriously, because this could have been a lot worse, like Mr. Hartel stated. Her blood alcohol level was extremely high. She was found off a parking lot in a ditch and partially out of the vehicle. I believe that based on her seeking treatment daily, I don't believe jail is necessary in this case. I believe lengthy jail sentence could impede treatment when she's already started the type of treatment that I believe may work for her. I do believe a short-term probation would be appropriate. I want to make sure that she gets into counseling based on the substance use assessment recommendation. I would ask for the alcohol highway safety victim impact panel class. And whatever else probation we believe is appropriate, whether that be testing or further aiding meeting the group. I am asking for reimbursement to handle FPD in the prosecutor's office in this case. I believe that's it. Thank you.
All right, thank you. Mrs. Hughes, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I have been going to AA since April of 2024, and this was just a relapse. I've been substance free for the better part of a year and a half before this happened. And it was an isolated incident for sure, but I realized that, you know, the gravity, what could have happened, and I'm so grateful it didn't. So I'm, you know, I am scared straight. I will never drink and drive again.
All right. Anything else?
Not that I think of. I don't want to sit here and make excuses. I have been to counseling for other things, and that's how I got into substance abuse. The AA to through the recommendation of, I went to Catholic Human Services a few years ago. For issues that, you know, depression mainly, stuff like that.
And I'm trying to remember, because I've read a few of these lately. And maybe it wasn't this one. But what did stand out to me in your assessment was something we don't see a whole lot, we see occasionally, is that recognizing there was a problem before you got to this stage. Usually it's this stage where people recognize there's a problem and then they go to take the steps. You took the steps before. I think you started in 24,
Yeah.
correct, AA? And then the assessment says that you drank on 3 occasions since April of 24. And then kind of for an unknown reason, this day you found yourself in a situation and just bought a bottle of vodka, right?
Definitely just a lapse of good judgment and seeking support or help. Usually if I ever had an inkling to drink away from home, or I mean at all, I would call my husband or my sponsor. My sponsor was out of town. I was doing Christmas stuff. I was stressed out and overwrought. I hadn't eaten, hadn't had anything to drink, and it just sounded good. I have no excuse.
Well, I have to say that the letters that I've read are they say what I would expect they would say. And I think I don't want to call it a stumbling block, but I think that's what it is. I mean, you realize there's an issue. I realize that people who have substance use issues stumble along the way before they're able to, I don't want to say they're cured, because we know you're never really going to be cured from the issue, but where maybe not living day to day with it in the back of your mind. So you've done some of the things that I would have wanted you to do before getting here, and even before getting in the car, you had done some of those things. So I think while we start with the presumption of no jail and no probation, I'm not going to put you in jail, so you can stop worrying about that. But when it comes to probation, I am going to put you on a period of probation. Even though we've got that presumption, I think in this case, there's a few hurdles to get over in which probation would be appropriate. One is that you test for a moderate alcohol use disorder. So there's a few ways you can test. One is not to have an issue. One's mild, moderate, and severe. So you're not at the top, but you're getting there. But you've taken the steps to hopefully decrease that down. So I want to make sure that you're continuing down that path. So I am going to put you on a period of probation for 12 months. The other concern I have is that the BAC was so high, 0.215. So for those reasons, I think it is appropriate for the probation. So during the 12 months that you're on probation, you're not to violate any law. Report is ordered. Not leave the state without the permission of your probation officer. Keep your contact and employment information current. Now, the good news in this is that these charges do allow for early release. So if you've done everything that we've asked you to do at the 6-month mark, you could be released from probation. If for whatever reason your probation officer does not think that you should be released, but you think that you should be, you can file a petition with the court. We'll have a hearing and I'll make that determination as to whether or not you should be released early. During the period of time that you're on probation, I want you to attend the Alcohol Highway Safety Education class and the Victim Impact Panel. Also, no alcohol. And you'll be subject to testing pursuant to the requirements of your probation officer. Normally, I wouldn't do this, but since you're already in the program, I want you to continue with some sort of recovery. It doesn't have to be AA, but some sort of program.
I love AA.
You know, I hear mixed feelings on it, so I'm glad to hear that. I'm also the sobriety court judge, and we rely heavily on AA. But I know it works for some people, and some people it doesn't work for. So,
It works if you work, and I just didn't work in a day.
well, and that happens. I also want you to follow the substance use recommendations. Any counseling that your probation officer feels is appropriate and what you're doing already now will probably work for that. You'll just need to let her know. And in particular, drug and alcohol counseling, which can probably be all rolled in together. Any programming that she feels is appropriate over and above what I've ordered. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $150 fine, $150 court costs, and $150 attorney fee. I'm only going to charge you for 6 months of the probation. If you end up staying longer than that halfway mark, you'll have to pay the $30 a month. But for right now, I'm only going to order $180. There is $100 reimbursement back to the prosecutor and $300 back to Cadillac Police Department. Those last two fees, in certain cases, law enforcement and the prosecutor's offices are able to recoup part of the expense in prosecuting these cases. And OWIs happen to be one of those. So that's what those two fees are for. Now, there's 1 day jail with 1 day credit, so you've sat your jail time. Ms. Dole, is there anything I've missed in a judgment of sentence?
I don't believe so, Your Honor.
Mr. Hartel?
No, Your Honor.
All right. Ms. Hughes, any balance that remains unpaid for more than 56 days has a 20% penalty added to that, but I'm going to waive that while you're on probation.
Thank you.
All right. Do you have any questions for me about your sentence?
While I'm on probation, am I not allowed to drive at all? Do I still have a restricted?
So the Secretary of State is going to take action against your license and you're going to get a hard suspension. The length of time escapes me right now, but you can talk to Mr. Hartel about that.
We did talk briefly, but I wasn't sure where that was wrong.
Yeah, and the courts no longer have any say over the licensing sanction, so that's entirely the Secretary of State. Ms. Hughes, I know this has been an eye-opening experience for you, and I never want to tell people to get over it and put it in the back of your memory, but you have my permission to move on from it, and don't beat yourself up over it.
It's too late.
Well, you can stop. All right. You can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan, and then you'll need to go downstairs to the probation office to get signed up for probation.
All right, thank you.
All right, thank you. Next is the people of the state of Michigan versus Tristan Lee Walker.
Thank you, Your Honor. Taylor and Hannah Presento on behalf of Mr. Walker, who is present and seated to my right.
This is case number 2682 SM. Who appears? Mr. Carnes?
Nate Carnes on behalf of the people, Your Honor.
All right, and we are here for a final pretrial. Is there any resolution?
Yes, Your Honor, it's my understanding that the defendant will enter a guilty plea to an added count of assault and battery, the 93-day misdemeanor, and the people will dismiss the charged aggravated assault.
Ms. Fioravante?
That is correct, Your Honor. However, we would respectfully request that the court would set this out a couple of weeks to allow our office to prepare a mitigation report and to allow Mr. Walker the opportunity to present all the good work he's been doing since he was released in this file.
Are you asking to set the plea out or just sentencing?
We would ask to set out, we would be fine with pleading today and then setting out sentencing, but we would ask that if he could remain on bond between now and sentencing so he can get us those documents. And he's already started to attend various counseling and things. He would like to continue those and be able to show the court that he's making those efforts. He is currently on probation for a different file, is my understanding.
Mr. Carnes, any objection to that?
No objection, Your Honor.
All right. Mr. Walker, have you heard what the attorneys have said the resolution of this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Please raise your right hand. You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
You may put your hand down and have a seat. Sir, it's my understanding that you will be pleading guilty to an added count of assault and battery. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. In exchange for that, the people will be dismissing the aggravated assault, which is the 1-year misdemeanor. Is that your understanding of the plea agreement?
Yes, Your Honor, it is.
Back on December 6th of last year, were you on probation or parole? Has there been a violation dealt with this? You know, Mr. Vento?
Thank you, Your Honor. My understanding is that when this occurred, he was at the jail.
Oh, so this was in the jail.
Yes, thank you.
Were you on bond in any other file? Do you remember reading and signing the advice of rights form, talking about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Most importantly, well, let me ask you, did you understand those rights?
Yes.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is it your own free choice to plea today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor, thank you.
Ms. Fiorvento, then, is the sentence or whatever he was in jail for, is that done with?
Yes, Your Honor. It's my understanding that he completed that sentence, I believe, February 4th. He was then released. When the release had occurred, I had been out due to a death in the family, so another attorney was covering. While I was out, he was released, and now he is out on probation for a different sentence.
All right, so the consecutive sentencing does not apply. It's already set that sentence. All right. The only reason I asked Mr. Walker is because if this had happened, which it sounds like it did, in the jail, this sentence could then be imposed to run after you served that sentence that you were in the jail for. But it sounds like you've already sat that sentence, so we don't have to worry about that. Then, Mr. Walker, to the allegation then that on or about December 6, 2025 in the city of Cadillac, Wexford County, how do you plead to an added count 2 of assault and battery?
I plead guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So it sounds like you were in the jail back on December 6th. And did you have some sort of altercation with a Colby Craig Paul O'Neill?
I did, Your Honor.
And why don't you describe that for me? What happened?
I assaulted him while he was sitting at the kiosk and was stopped by a CO.
And how did you assault him?
I hit him in the face.
And why did you hit him in the face?
We had a disagreement.
Okay. Was it a verbal disagreement?
Yes, Your Honor.
And he didn't ask to be hit in the face?
No, Your Honor.
Do counsel believe that the defendants provided a factual basis in which to accept the plea and the court rules been complied with?
Yes, Your Honor.
Yes, Your Honor, thank you.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Walker, I find you guilty of an assault and battery pursuant to the plea. The aggravated assault will be dismissed at the time of sentencing. Pursuant to defense request, we will set this over for sentencing. Ms. Fiorvento, I don't remember, did you ask for a certain time frame?
I would say we should have maybe 3 weeks. I don't want to overburden our social worker, but I am going to ask him for his mitigation report in this file. I know that is not common for a misdemeanor matter, but I do believe it would be prudent here.
All right, we will go ahead then and set this out for 3 weeks. Sentencing. Any objection to bond continuing, Mr. Carnes?
No, Your Honor.
All right. Bond will continue in the meantime. Mr. Walker, you can go out to the front window where you checked in, get a copy of your next court date, and just a reminder that your bond conditions continue.
Thank you
All right.
very much, Your Honor.
Thank you.